this is Matt on the Moon Family Sedan channel. Did you know that the SEC is on just a touch of a losing streak when it comes to Supreme Court cases? In fact, having lost 4 of the last 5 Supreme Court cases that it was a part of. I wasn't aware of that fact, but it just seems to me that as terrible as the SEC has always been, at least for the last few decades at a minimum, despite that, it does seem that in recent years, they've become even more emboldened to just do whatever the hell they want. And, perceptions of the public or judges be damned. They're just going to do what they want to do. But they are getting swatted down like flies when it comes down to it. So even if we get some sort of terrible ruling on the district court level with Judge Torres, which is not what I'm anticipating, even if Ripple loses, I still think there can be some good stuff in there for XRP holders for clarity for us. But even if it's really, really bad, there's still the appellate level court opportunity, in which case it's more likely, attorneys within the XRP community have articulated for various reasons that it's even more likely there that you get a good ruling for Ripple. And beyond that, the next level is the Supreme Court. And at that point, it's on. So I'm going to share with you thoughts from attorney John Deaton, and he also shared some thoughts today, just breaking down just the non sequitur logic used by the SEC and come to the conclusions that they've come to. But before going further, I do want to be clear, I do not have a legal or financial background of any kind. I'm not offering legal or financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun, damn it. And if you don't like it, you can just get out. So here's a tweet from Stuart Alderati. This is Ripple's general counsel, so that he's their top in-house legal guy. And today he tweeted out the following. The SEC has lost 4 of its last 5 cases in the Supreme Court, thanks to the few that had the courage and resources to fight back against the SEC's bullying and clinging to stretch legal positions that were not faithful to the law. So a couple of things on this. It's certainly true that most don't have the wherewithal to push back. Even if you have the mental fortitude, do you have the cash? And it takes years. I mean, from beginning to end, from first legal action filed to end, it's not uncommon for things like this to take 5 to 7 years. That's not uncommon. And it's also the case, by the way, that the Supreme Court doesn't have to take up every case that is thrown its way. They get to choose. But I will say, for a case as highly consequential as the SEC v. Ripple case, I think it's a virtual certainty they would take it up. A case like this, oh yeah. This is of momentous importance. There's clear uncertainty. Let's just word it like this. If it gets to the point where, you have a problem with a district court ruling, and then it gets to the appellate court, and then there's still an appeal from there. And if you look at the specific arguments that have been made to that point, I mean, even just on the district court level, because we're already privy to a certain amount that's public, it's like very easily clear that the SEC isn't operating in good faith. And Attorney John Deaton has pointed out in the past, with the current makeup of the Supreme Court, regardless of your political leanings, the current makeup of the Supreme Court, it would weigh in Ripple's favor because these individuals are against government overreach just in a general sense. If they see government agencies reaching beyond the power that they've been congressionally granted, they get swatted back because they are overreaching and it's illegal. And with the makeup of this Supreme Court, they are by the book. They're clearly, by and large. Not all of them, but I mean, you're talking about the majority of the Supreme Court justices, which side, appointed. So, and I'm not making a political commentary on that whatsoever. I'm just saying that is the case. Attorney Deaton observed that. It is true. It just is. That's good for XRP holders, regardless of your political leanings. I'm just stating a fact. Now, Attorney Deaton retweeted that from Stuart Alderati, and he said, I have no doubt Ripple will win, and the Supreme Court will shut down the SEC's gross overreach. The West Virginia versus EPA case is all you need to read to agree with me. Ripple's summary judgment brief is already an extremely well-written appellate brief. Exactly, and I've covered the EPA case, mentioned it anyway, not in terrible depth, but I have mentioned that, so I'm going to gloss over that for this particular video. But yeah, the Supreme Court found that there was overreach there by the EPA, and swatted them back. This is what they do. It's like if you're a government agency and you're operating within the confines of what Congress has allowed, then the Supreme Court justices are like, hey, thumbs up, good job. If you go past that, they say no and they swat you back. The SEC has gone far beyond what is allowed by Congress. Period. Couldn't be more obvious. And look, the SEC, they bring all sorts of frivolous nonsense cases. Just to kind of bring the point home, here's a headline from just a few weeks ago from Axios. Elon Musk wins securities fraud case over 2018 tweets. So you can win. And I know this isn't a Supreme Court case, but I'm just pointing out the SEC does lose. But you got to push back. You got to have the cojones to do this. Here's another headline from October 2013, almost a decade ago. Billionaire Mark Cuban, cleared of insider trading, blasts U.S. government. And so this is something that, I mean, took years to get to a conclusion here. Billionaire Mark Cuban, again, somebody with a war chest willing to do this, has the mental fortitude to see it through. It's estimated that if he had just settled, it would have cost him about $2 million. But he cleared his name, but it probably cost him about $16 million. How many people are going to be able to do that? Like, not many. The SEC, it's just an agency full of bullies. That's basically what's happening. And look at this from 2006. SEC loses insider trading case. Court distressed by counsel's conduct. And this top part really caught my attention. The Securities and Exchange Commission was recently handed a significant defeat in SEC v. Heartland Advisors, Inc. when a U.S. district judge dismissed civil insider trading charges levied against an advisor and his client. While the decision was itself a damaging setback to the SEC's ongoing efforts to deter insider trading, the court added insult to injury in an opinion riddled with jabs at the SEC counsel's professional conduct. Now that last part, that's the reason I'm even mentioning this in my video. Nothing's changed, folks. That was from 2006. It's now 2023. And just last year, you had Judge Sarah Netburn in the SEC v. Ripple case, the magistrate judge, stating that, and just paraphrasing here, that the SEC does not appear to be operating that within, in good faith, and that they were hypocritical, and they're not operating in good faith in allegiance to the law, something to that effect. These are not people operating in good faith. So you can defeat them, but you got to have the mental wherewithal and you've got to have the war chest. And the good news for XRP holders is that Ripple's got all of that in spades, and they will take this damn thing to the Supreme Court. And I do firmly believe the Supreme Court will be highly likely to take this up, especially when they see that it's about government overreach. Oh, you better believe it. You better believe it. So even if we have to wait that long, I'm going to sit on my XRP, even if we get a disaster scenario, as long as I have to. I've made up my mind. Like, that's it. Period. Plus, I'm sufficiently diversified anyway, so it's not like I'm going to miss my opportunity in crypto during these incredible times. I mean, unless the SEC attacks every other coin that I own, so I guess that's possible. But outside of that, you get what I'm saying here. But take a look at this. So there's this story from Crypto News Flash titled "SEC can get only this victory against XRP, but Ripple will win big," says lawyer. XRP to hit $10? Question mark. And so they were talking about the biggest danger, what Attorney Deaton was saying is the biggest danger for Ripple. And I already covered that in a separate video, so I'm only going to mention it here. But what he was talking about is that it's not just the selling of XRP, and this is something I didn't realize for a long time. It's not just the selling of XRP that could potentially be an illegal securities transaction or an infraction, but it's also if something is perceived as an offering. If you're even making an offering, that can be illegal, in fact. And so that's what they were citing in the article. And then Attorney Deaton expanded upon this. So he shared that article and he said, "I always like to back up anything I say with facts, explaining why I believe the way I do. In the next tweet of this thread, I'm going to quote the SEC's summary judgment argument versus Ripple. The following quote perfectly summarizes the SEC's theory in a nutshell. Quote, defendants do not dispute that they offered and sold XRP in exchange for money, which suffices to establish the investment of money aspect of the Howey test. Defendants' statements and efforts as to XRP establish the other aspects of the Howey test as a matter of law," end quote. And so, by the way, I got to pause and just say this. Anytime I've read this before, I just sit there saying, okay, so they're saying there's an investment of money, so that's one prong of the Howey test. And then it sounds to me like they're arguing because that one prong of the Howey test is satisfied, that means the other prongs of the Howey test are automatically satisfied. Like, reread that. That's what, like, they're actually saying that. It's so stupid. Anyway, Attorney Deaton continues out. He says, now that's an interesting way to approach the Howey test. I've said in the past that the SEC is attempting to apply the functional equivalent of the but-for test to securities law. The theory is, because Ripple executives created XRP and the XRP ledger and then undertook efforts to help create a secondary market, all XRP, including XRP traded in the secondary market, constitute securities, regardless of the seller or the circumstances surrounding the sale. We can all agree, even if you despise Ripple and believe XRP was sold as a security, the SEC's theory, if successful, would establish a dangerous precedent. As I say in my amicus brief, this is not how the Howey test is applied, nor is it an example of how the law functions. The SEC didn't allege or prove specific transactions, but claimed all transactions, past, present, and future, meet the Howey test as a matter of law. The SEC claims Ripple's statements and efforts satisfied the remaining prongs of Howey without conducting a specific Howey analysis. Ask yourself, how does Ripple's statements and efforts establish the common enterprise factor as a matter of law? The SEC actually shortcuts the analysis and argues that XRP itself, the token, represents the common enterprise. The SEC argues, and this is a quote from the SEC, the escrow account's purpose was to remind investors of the common enterprise XRP represented, end quote. Thus, XRP represents the common enterprise. Remember, the SEC argued, and this is another quote from the SEC, XRP, including XRP traded in the secondary market, represents the investment contract, end quote. Thus, XRP represents both the investment contract and the common enterprise. So folks, think about this. XRP, it is the investment of money, with the expectation of profit, and it's the common enterprise. So it's like, this is why when I first read it, it's like they're arguing one prong of the Howey test, investment of money. Since that happened, all other prongs are satisfied. What in the ever-loving hell is that? That makes no damn sense in the world. It's so irrational. As much as I would love to see the Supreme Court rip this to shreds, and they would, I'd much prefer to have this just concluded now so we don't have to go through the years of pain to get to that point, because it would be years down the road before we get there. Anyway, Attorney Deaton continues. The SEC also argued, quote, this is again from the SEC, Ripple offered and sold XRP for money as a common enterprise, end quote. Here, the SEC literally claims that XRP itself is the common enterprise. Facepalm emoji. Again, because the SEC said Ripple offered and sold XRP for money as a common enterprise. Literally stating XRP itself is the common enterprise, which has been a moving target. If you've been following the case, then you know, like, what they've asserted is the common enterprise. It's just been shifting. They don't know what the hell they're doing, right? They're just kind of winging it, right? Because it's not about a faithful allegiance to the law. It's about whatever we want, because reasons, in the moment. And then Attorney Deaton says, even if you hate Ripple, you must see the inherent flaw in the SEC's conclusory and circular reasoning. According to the SEC, because it represents both the common enterprise and investment contract, any purchase of XRP automatically satisfies all prongs of Howey. The SEC's obsession with focusing on the token and not on the circumstances surrounding the offering as a whole allows the SEC to sidestep a legitimate Howey analysis. It takes unconstitutional bootstrapping to a level not seen before. This is why I said the SEC may have snatched defeat from the jaws of victory. As I point out to Judge Torres, quote, simply put, the allegations contained in the amended complaint are quite possibly the most overbroad, far-reaching claims ever made in an SEC enforcement action, end quote. Yeah, so it goes back to something I was saying earlier in the video, because I think Attorney Deaton's right, from what I've seen anyway. If there's something worse pointed out, maybe I'll agree. But I think John Deaton has a good point here. They become emboldened, and it's a more disgusting, rotting agency the more time passes. getting away with all sorts of nonsense. And that's why you see now they're so emboldened, but they've gone too far. And now the Supreme Court has ruled against the SEC in 4 out of the last 5 cases that have been brought to the Supreme Court. Well, that shouldn't be the case. If you're operating in good faith, like, are you that untalented, or are you just not operating in good faith? I think they're just not operating in good faith. And it is hard. So, like, even though they're not actually stupid people, they do have trouble, like any liar would, keeping track of their lies, resulting in conflicting arguments. But that's why it's better to just be an honest human. Then you don't have to worry about it. You don't have to remember what you said. You just say the truth. But even if you're smart, and even if you have talent as a lawyer, if you're going to be dishonest, you're going to slip up at some point, especially if you're making like a ridiculous quantity of lies and making a crazy novel theories. Yeah, that's pretty much what you'd expect. So I didn't know that stat when I woke up today, but 4 out of the last 5 Supreme Court cases swatted down, SEC loses. That's cool as hell and well-deserved. So again, if it comes to it, I'm very optimistic Ripple's going to be on the right side of the history. It'll be proven. Yay for XRP holders, but it will be a painful journey if it comes to that. So I think what's most likely is we won't see it get to that level. I think it's more probable after this district court level case, there's going to be a conclusion. There's going to be a settlement. I mean, it's still possible there could be a jury trial. But even if there's a motion for, or one of the motions for summary judgment, Judge Torres rules in favor of one of those, there will be settlement after that, meaning the remedies portion of all of this. And it's probably going to get squashed there, and there can even be an agreement so that to make sure both sides get closer to what they actually want. There's part of the agreement is you got to give up the opportunity for appeal. So I think something like that might be more probable than going to the Supreme Court, but I'm not ruling it out. We could end up at the Supreme Court. I just don't think it's the most probable thing at this particular point in time. But stay tuned. We gonna find out together. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the Moon Family Sedan.